Good morning. My name is Tom Gallagher, and I'm a practicing Catholic at Riverside, Connecticut, at St. Catherine of Siena Parish, where we have terrific priests and deacons and lay people. Thank you for coming out this morning. There are some materials being handed out that offer a full statement and some background information. I'm joined this morning by Dr. Paul Lakeland from Fairfield University. I'd like to offer some comments related to Senate Bill 1098, the Connecticut's existing Religious Corporation Act, which many people don't even know exists, and the need for appropriate change. For several years, I have publicly advocated for a change in the way Catholic parishes in Connecticut govern themselves. 2 years ago, I sat down with my own state representative, Republican Dolly Powers, and shared with her some ideas for appropriate change. Representative Powers discussed this with the Judiciary Committee. After she retired, I reached out to Senator Andrew McDonald and had the same discussion in writing and primarily in email. In fact, I've never met Senator McDonald. Separately, others from the Darien Parish St. John's also spoke to Senator McDonald to suggest that this earnest attempt to improve Catholic parishes is somehow related to gay marriage is simply inaccurate and unfortunate. Not a single bishop, priest, or layperson who is against the spirit of Senate Bill 1098 has stepped forward to suggest that the current model represents the absolute best practice from a governance standpoint. The multiple well-publicized embezzlement cases in Greenwich, Connecticut, and Darien represent just one reason why governance change needs to take place. A more compelling reason is to engage the increasingly disengaged Catholic laity, particularly young adults, in a new way that fosters greater commitment and ownership of their parish alongside bishops and priests as co-fiduciaries. Now, the question comes up, what motivates us to do this? Just yesterday, a poll came out and said that the fastest growing religious sector in the United States are those who are non-affiliated. Weekly Mass attendance in the Catholic tradition is roughly 25% of the population. In New England, the Catholic population is actually decreasing. In this region, waves upon waves upon waves of parish closings should impel all Catholics to consider new ways in which we organize ourselves. Many lay people, priests and deacons, have mentioned to me that they like the spirit of 1098. But like me, we all agree that the bishop and the pastor must be included as voting members of this board. Now the question is how can we organize ourselves in a more compelling fashion? I'd like to point out 3 examples. Father Michael McGivney created the Knights of Columbus over 125 years ago as a lay-governed organization. And today, it distributes over $100 million in donations and contributes 75 million volunteer hours, affirms priests, affirms bishops, and affirms the Pope. It is no wonder that this great Connecticut priest is well down the road to sainthood because he believed in the laity. The second example is Sacred Heart University. This university started out as a Diocese of Bridgeport college to serve the inner city poor of Bridgeport. To then Bishop Egan's credit, now Cardinal Egan, he converted this diocesan corporation into an independent Catholic college. Under the leadership of Dr. Sanera, this Catholic college is now the largest Catholic college in New England. And its board consists of the bishop, diocesan priest, and many, many lay people. Lastly, the Archdiocese of Hartford has created an integrated board structure at the St. Thomas More Chapel and Center that serves Yale University and its neighborhood. That particular board has the Archbishop, the Vicar General, a pastor from the Archdiocese, and a very substantial 12-member lay board. This entity offers a terrific model of an integrated board structure for Catholic parishes, clearly permitted under the First Amendment, the Connecticut state law, and with the complete blessing and engagement of the Archdiocese of Hartford. If this governance model works for Catholics at Yale University, it will work for Catholics on Main Street. Now, this process of amending the Religious Corporation Act requires greater legal clarity. Serious and complex questions of law and religion exist such that the act itself, that's been in existence for decades, may be unconstitutional. And I draw your attention to Attorney General Blumenthal's statement where he himself questions the validity, the constitutionality of this existing act. On behalf of many people who yearn for new ways to organize ourselves as Catholics, late yesterday, I asked Senator McDonald and Representative Lawler, co-chairs of the Judiciary Committee, if they deem it appropriate to secure a definitive legal opinion from the Connecticut's Attorney General on the constitutionality of the existing statute. And to the extent the existing statute is constitutional, to provide the legislature and citizens of faith a pathway to amending that act where appropriate. If these legislators agree with this vital step, it'll be a great day for citizens of faith who are Catholic, as well as all citizens of our state. In the meantime, we look forward, those of us who are in favor of the spirit of Senate Bill 1098, to begin an in-depth dialogue with the Archbishop of Hartford and other bishops of Connecticut, and with all people of goodwill on this compelling issue of the day. I'll ask Dr. Lakeland to read his statement. Oh, I'm sorry. I'm not going to do that. Okay. Now, related to this request to have the Attorney General take a thoughtful study of the issue, I've also asked that tomorrow's public hearing be postponed.
And have you heard any response to that request?
Why don't we have Dr. Lakeland, and we'll come right to that question.
Good morning. Thank you for being here. As Tom said earlier, my name is Paul Lakeland. I teach and have taught for 28 years at Fairfield University. My specialty is the Catholic Church, and within the Catholic Church, my specialty and my two most recent books are on the role and responsibilities and rights of lay people in the Catholic Church. The first thing I want to say is that the legislation that we have been looking at, the proposed legislation, is a really important service to the Catholic people of Connecticut. What it's done is it's brought a matter of great importance, that is the role of lay people in the administration of their parishes and in the administration of the finances of their parishes, out in the open into the public arena, within the church and beyond the church, which is where it should be debated. This is an issue that has been debated increasingly in the Catholic Church, not just in Connecticut but around the country, because of the kinds of developments that Tom has referred to do with mismanagement of funds, and because of the financial problems of the American Catholic Church as a result of the extraordinary cost of the sex abuse scandal, and also because American Catholics within the last 20 or 30 years, 40 years perhaps now, have been becoming better educated and more interested in taking a role and having a responsibility for the upkeep and the financial maintenance of their own institutions. The fundamental issue behind this legislation from the perspective of Catholic lay people is, in a parish situation, lay people give absolutely every cent of the money which maintains that parish, which provides for the salaries of the pastor and indirectly the bishop, and Catholic lay people have absolutely no rights or responsibilities in church law for executive decisions about how that money is managed. Something people don't realize, and something which has not been spoken about in recent days, is that the present situation of fiduciary responsibilities in Catholic parishes is something that is part of a process of change that has been going on certainly for 2,000 years. That throughout 2,000 years, the way the church has organized itself locally has constantly been changing. People do not realize that the early American church in the late 18th century was run by a system of lay trusteeship. They do not realize that in the early 19th century, the Bishop of Charleston, John England, established a bicameral legislature for his diocese, a house of the clergy and a house of the laity, and the laity were responsible for the financial management of the diocese, the obtaining and maintaining of property, and so on. People do not realize that the church in Philadelphia in the 19th century and the church in New York City in the 19th century were established by lay boards of trustees. And throughout the 19th century and into the 20th century, there was a debate backwards and forwards between lay people and clergy and bishops about the proper way to organize. The present situation, which is in law in Connecticut state law, represents one of those models. But when that was put into state law, it didn't stop this 250-year long American dialogue continuing. And it continues today, and the evidence of that is that within the church there are honest disagreements about the best way in which lay people can exercise responsibility for the church which they maintain financially. I think the legislators who have been supportive of bringing this material forward deserve our gratitude as Catholics, not the vituperation that they have been experiencing in recent days. But the heat of the debate, as Thomas suggested, the heat of the debate in the last few days has revealed considerable constitutional complexity in both the present and proposed law. And I think, like Tom, that it is a wise and productive step to refer this matter to the Attorney General for his judgment. In the expectation, I should say, that what will follow will be a thorough examination of the whole question of religious corporations in greater depth and at greater leisure than can be achieved under the present circumstances. I would like to hope that the Catholic Church in Connecticut, from the bishops to the laity, will see this as an opportunity to explore how the Church can better manage its affairs and allow for a proper and substantial role for the whole people of God. Thank you. I'm sure we can take questions now.
So I have a question. Why the Catholic Church? Like, for example, I grew up going to a Protestant Lutheran church, and I can't say that the parishioners had a whole lot to say of how the money was spent. I mean, there were a few people. But why just the Catholic Church? Are you saying it's different than, let's say, other Christian churches on the Protestant side?
Well, that's a great question. The state law itself, if you have a chance to look at the law, it actually has particular sections related to different faith denominations. So the Religious Corporation Act includes, quote, Protestant Episcopal Church, the Methodist Church, the Lutheran Church in America, the Augustana Evangelical Lutheran Church, and then the Roman Catholic Church. So anecdotally, other faith traditions, the religious leader doesn't get involved in managing the finances or controlling the finances. So that's an interesting distinction. One of my hopes is that with a broader, more thoughtful discussion, the best practices in terms of governance of religious corporations will become known, that we can learn from one another what works best with respect to the temporal affairs of these religious corporations.
Now, in your written comments, you say that Senate Bill 1098 goes too far. You cite as one example, bishops and pastors need to be voting members of a robust functioning parish corporate board. Are there any other examples you could cite where there were components of the bill you weren't completely comfortable with or that you thought needed to be modified?
That's a very good question. My little idea was to simply add a few more lay trustees to the Catholic Parish Corporation Board who would be permanent members on a rotating, on a multi-year basis. So by and large, other than carving out the bishop and the pastor, which I don't agree with, by and large, the essence of that bill is good. So for example, the whistleblower statute or provision should be in, and every religious corporation should have the right to a whistleblower statute if they feel that something's wrong within their place of worship.
Now, if you go back, this hearing has already been published. So what did Andrew and Representative Lawler, Senator McDonald and Lawler tell you about? And we've been told that a lot of people are planning to come up to that hearing.
Well, when I spoke to the legislators late yesterday, they were frankly surprised. They wanted to take it under advisement, and they wanted to sleep on the issue overnight. So I would just say that they would be in the best position to figure out the schedule going forward.
Professor, it appears to me that you made a very eloquent argument here. Why do we need the Attorney General? It appears as though you've already researched this, that there's clear precedent for some sort of representative democracy representation in Catholic parishes. You listed them all, or you probably only listed some of them.
I listed some of them, yes. I mean, there's clear precedent. What there isn't within the polity of the Roman Catholic Church is a structure that allows for these changes to be made. To go back to the question that was asked earlier, one of the big differences between the way in which the Catholic Church is structured, its corporations are structured, and the way in which I would be pretty sure every other church is structured, is that the other churches either have a synodal form in which people from the laity, from the clergy, from the episcopacy, if they have an episcopacy, set the rules, or they have a congregational form in which each individual community governs itself, and they have to work it out within themselves. In the Catholic Church corporation structure, the bishop is the head of the corporation of each single corporation, that is, each single parish. Under Connecticut law, he serves on a 5-person team of the bishop, the vicar general, the pastor of the diocese, and 2 lay people appointed annually by the bishop. So that one of the things that you have to know about the role of lay people in the Catholic Church is there is absolutely no mechanism by which lay opinion can have a formal role in influencing church opinion. Of course, they can be consulted, which has the result of what that tends to do, and I think the present case is a good case in point, is that tends to put Catholic lay people in the position of when they are working in what they see to be honestly for the good of their own church, they are placed in the position of appearing to be dissenting from their church.
The current structure was established in state law already and was established at the request of this diocese, was it not? Or the church?
The bishops of all the state. The bishops came to the legislature in the 60s.
And wrote this so that they already are established under state law. This is just a changing of an existing law.
This would be amending the existing law, yes.
A simple question. Why is each individual parish a corporation? Why isn't just the Roman Catholic Diocese in Connecticut a separate corporation?
The best sense is that by incorporating every local parish corporation, you know, it gives protection under law of the assets. So that if the diocese runs into a problem, is getting sued, you cannot just gather up every parish and say, okay, we'll take every parish piece of real estate. So there's some practical and good reasons to incorporate every parish. But as a practical matter, I'm not aware of any governance expert who thinks it's a good idea for an individual to be on 87 corporate boards at the same time.
That's how many parishes?
Well, in my diocese of Bridgeport, in the Archdiocese, it's even more. So there are some practical challenges to the current model, just practical challenges that create impediments to good governance.
Mr. Gallagher, were you personally affected at all by what happened in Darien with the priest who's accused of taking or embezzling 1.4 million? I mean, have you had...
No, I'm a parishioner of St. Catherine of Siena in Riverside, which has great priests, by the way.
I read that. I was just curious how you got involved in this then.
No, it's a good question. It's a good question. I've been in Connecticut for 17 years, and in the late 1990s, I was a trustee at St. Mary's Parish in Greenwich Avenue, in Greenwich. And that was a very fulfilling experience. But I also understood what the limitations are of the model. And so as time went on and the challenges the church has faced with the sexual abuse crisis and with the parish closings and now with some of these financial scandals, you know, I subscribe to the prophet Obama, who said the status quo is not an option. You know, I think we need to make change, appropriate change.
What's the rest of your background? You're also a KOC.
My background, I've worked for the Missionaries of Charity, Mother Teresa's Order, helping to develop and to administer the Mother Teresa Center for about 3 years, 2.5, 3 years. I did that on a pro bono basis. I've worked for a Jesuit not-for-profit focused on the education for the poor in Latin America. You know, I'm a Eucharistic minister at Greenwich Hospital. Yeah.
What's your profession? Are you an attorney?
I have practiced law. I'm no longer practicing law. I have a small business, a startup, and that I own and I manage.
Tom, this follows up on Shelley's question. Are you asking the lawmakers to approach the AG to review just the Roman Catholic carve-out of this, or the entire thing?
Well, the fact is that I've asked the legislators of the committee to go to the AG and get a definitive opinion on the constitutionality of the entire act. You know, we're just one part. Yeah, I mean, because the Attorney General himself said just today or this morning that grave questions of constitutionality affect this piece of legislation. So getting clarity on the law itself will be a good thing for the citizens of Connecticut.
How do you balance Bishop Lori, since all this attention started on this issue of changing the law? I mean, what's been his reaction to your simple idea?
Well, the little idea that could. I spent Saturday with my wife and our dog at Central Park enjoying the spring weather, and Todd's Point on Sunday. So I haven't been in touch with Bishop Lori or his people, his staff. So I don't know. I mean, obviously the public comments speak for themselves. I can't really react to that, other than to say this has nothing to do with gay marriage.
So let me just make sure I'm clear here. So what you're asking for, when you say lay people, are you referring to parishioners? Would that be another way to say it?
Yes.
And you want them to be part of a board that decides the finances, or that they have complete control of the finances?
No.
I'm confused.
Yeah, that's
Okay.
fine. This is a complicated issue, and the fact is different faith traditions do it differently. So in the Catholic setting, what I've asked for is that additional lay people, parishioners, be elected by their particular congregation to serve on the parish corporation board and to have a single vote with respect to just temporal matters. That is, legal risk issues, insurance, budgeting, those kinds of things. And no vote with respect to the faith and the sacraments and theology and dogma and so on. That would be reserved to the bishop.
Who's involved in the financial side and have, okay, right? I mean,
With a vote, with fiduciary duty and with a vote.
Right, a vote meaning it's not like, yeah, they have power on this board. It's not just for ceremonial purposes.
That's correct.
Okay.
Yeah, and also the idea that this additional number of lay people are elected from the parishioners. Right now, they're appointed by the pastor and the bishop. You know, he gets his friends. They may be very well experienced, they may not be, but they're the two lay people appointed annually, which means they can be unappointed annually.
Do you really need a law to do this, though?
It wasn't my idea to, in 1960, to go to the legislature to put this in law. So
right now, the current law excludes parishioners, and you want them on. Would that?
Yes, it excludes them in two ways. One is they're not elected. They're appointed annually, which means they can be unappointed annually, and that the fact is that when you have 87, again, my diocese, 87 parish corporations, it's almost physically impossible for the bishop and the vicar general to be meeting bi-monthly or monthly with 87 separate corporations. So there's some practical impediments to the current model. So if we expanded it, there would be ways in which to make it a robust, functioning governing board.
So there's some concern within the church about the bishops and the pastors not getting a vote. And you said that you're against that idea, but what you seem to say right there, which is they're on 87 different boards in the Diocese of Bridgeport, so how can they vote, seems that you're for it. What is your response to their concern about their votes being taken away of the parishes that they're in charge of?
The bishop and the pastor must be voting members, period. Now, how can an executive serve on 87 boards at one time? Well, one way to do it is to, in the law, give the bishop the right to have a proxy assigned to his position, so that person sits in on meetings and has the right to represent the bishop. So there's some technical adjustments that can be made to make it a much more fluid and enlivened entity. But they must be voting members of the board.
Bishop Lori yesterday said that this is a threat to the hierarchical tradition of the church. Can you answer that? Why is this a threat to the hierarchical tradition?
Could you repeat the question?
Why the Bishop Lori said this is a threat to the hierarchical tradition of the church. Could you respond to that?
Yes. It could be interpreted to be a threat in two ways. One would be if this was the assertion of the prerogative of state law to direct the functioning of the Catholic Church. The other would be the actual issue itself. In canon law, which is the law that governs the church, lay people have no executive authority whatsoever in any aspect of church life. Their role on finance committees, on boards of trustees, on parish pastoral councils, on a diocesan synod, if one should ever be called, is always described in canon law as, quote, is always described as consultative only, unquote. A particular reading of Catholic Church history and theology sees that as a reflection of a very high, I suppose that will be the right word, a high understanding of the authority of the bishop. That the bishop is, in fact, the first and last word on all executive decisions within his own diocese. So if you look at the church that way, then you would see any changes that gave any executive responsibility to lay people, however sort of low down in the structuring and functioning of the diocese, to be a challenge to that understanding of episcopal authority. I think you have to say that there are many other people, including many other bishops, who would not understand episcopal authority to be so tightly controlling in the way that you describe Bishop Lawry's words. The history of the Catholic Church is the history of a lot of changes. For the first 300 years of the Catholic Church, bishops were chosen by lay people. And things have gone backwards and forwards over many years, and nothing is ever absolutely final in terms of the structures of church organization. But certainly, I think, does that answer your question?
Well, so you agree this is a challenge then to the bishops?
This, I would agree with this, that a law, or not just a law, but a change within the church which gave executive authority to lay people over the governance of their parish would be a dramatic change from the way things have been conducted in the American Catholic Church during the last century. Not necessarily before that, and not necessarily in other national churches around the world.
Voicing some concern for the reaction that Andrew MacDonald and Mike Lawler were getting. What kind of reaction were you getting on campus yesterday, Professor Lakeland?
Not much, because I spent most of the day talking to people from different radio and newspapers and had very little chance to talk to anyone. I think on a campus community, like any other community, you would find people who would agree with me and people who would disagree with me. So, excuse me?
So that's what you were finding then?
Well, I wasn't talking to... nobody was talking to me about it much. I mean, most people on the university campus, I mean, I deal with faculty. Most faculty on the university campus are not particularly interested in this issue anyway. So,
why is that?
Because many of them are not Catholic, and many of them are not plugged into church issues. It's an academic institution.
Have you tried to pursue your initiative through canon law, through changes in canon law? Have you tried to make that attempt?
I have not attempted to propose changes to canon law. That would be a long road to hoe. So the fact that this corporate governance model exists in state law seems to encourage engagement of the legislature to help find a pathway forward.
If I could just add one thing to that. In the Catholic Church, the Bible never changes. Theology develops, and canon law is periodically revised. The last time was in 1984, so certainly what can be revised could be revised again.
Maybe one or two more, but I think it's up to you. One or two more questions?
As far as the hearing being postponed, is it postponed or is it not? We don't know yet.
I think that the co-chairs, Representative Lawler and Senator MacDonald, have to make that decision. They will probably have a decision, but they just got this idea last night and wanted to think about it overnight. That it? Thank you very much.